Let's move on to the court's interpretation of your gag order requests. Mr. Smith, America was founded on the principle that the government doesn't silence political speech, in particular speech before it happens. You sought a prior restraint against President Trump without a single violation of pretrial release. In fact, there was no real-world harm that you could articulate justified giving the federal government the power to silence him as a presidential candidate, was there?
The court granted those motions and found that the prosecutor did not have to wait until someone was harmed to make such a motion.
Actually, the request was rejected when the case was actually, when you actually were not able to, it was restricted, correct? The gag order was restricted, correct?
Well, we filed for an order in the district court. The district court granted an order. President Trump appealed that order. The Court of Appeals absolutely agreed that there was a basis and that the threats to witnesses that came from the targeting by Donald Trump were real and that we had a duty to protect them. You are correct in that the Court of Appeals narrowed the order, so the order covered witnesses, court staff, the judge, and my staff. The difference was that it didn't cover me anymore, which I was fine with.
Did you have any evidence that President Trump's statements about the cases against him intimidated witnesses or prevented them from coming forward?
I had evidence that he said, if you come after me, I'm coming after you. He suggested a witness should be put to death. The courts found that those sort of statements not only deter witnesses who've come forward, they deter witnesses who've yet to come forward.
But you weren't able to identify a single witness who didn't come forward because they were intimidated by President Trump.
We had extremely thorough evidence that his statements were having an effect on the proceedings that is not permitted in any court of law in the United States.
Don't you think it's a pretty low bar to clear if you're trying to silence a candidate for president? I mean, if you can't identify a single witness who's intimidated, that maybe you should reconsider the gag order?
Both courts upheld the orders, and it is not incumbent on a prosecutor to wait until someone gets killed before they move for an order to protect the proceedings.
Wait just a second. We have one more thing to share.
We want to say a heartfelt thank you for watching and supporting PBS News.
Without you, we simply wouldn't be able to provide the news and the information that you trust.
So thank you from everybody here at PBS News.
Support journalism you trust. Support PBS News. Donate now, or even better, start a monthly contribution today.